Data is the new oil. This is a phrase that's tiresomely repeated at every tech conference nowadays. Its repetition, however, is justified because it is rooted in the reality that we are all living in. Today, nearly every decision taken by an organization or a government relies on trillions of bytes of data that is collected with every move or click we make online. However, data is sensitive, and the lines around its ownership, collection, use, and legality thereof are often blurred. Dr. Orgo Sengupta is the founder and research director at the Vidhi Center for Legal Policy. In our first keynote address, Dr. Sengupta will give us context and insight, helping us understand the future of data protection and privacy law in India. Dr. Sengupta.
Morning, everyone. Thanks very much for having me here today. As a caveat, I'm wearing two hats. The first is of a sports fan, particularly an Argentina fan today, because I thought this is a rare opportunity for a data protection lawyer to come to a conference and not wear a suit and tie. So that's the first hat I'm wearing. And the second hat, incidentally, is that of a data protection lawyer who's been part of the committee which has drafted a data protection bill for India. And I was thinking that this is such an early morning start in Bangalore, and so what can we do to make this a bit interesting? I didn't want to go over the provisions of this bill that we have in seriatim, because I think that would put you to sleep very early in the morning, or would actually take you to your phones to see the wonderful innings that Steve Smith played yesterday, which I saw on the way to the auditorium. But so I thought that it would be interesting to think a little bit about the interface between data and sport. And it took me back to what George Orwell said, that sport is war minus the shooting, though someone might describe the Birmingham Commonwealth Games as that now. I hope they can sort that one out soon enough. But the use of data in sport has certainly bolstered sports' reputation of being this joust between opponents and finding the best ways possible to win. Like in every other sector, the use and abuse of data has prompted new ways of thinking and doing things. In sport, and I don't need to tell you all, as sport data has changed the way in which we're looking at player performance, the way in which rules are set, the way in which contracts are negotiated. Thanks very much. And in a number of areas, data has and is continuing to change the ways in which sport is played. So in this brief keynote, I'm going to do two things. First, I'm going to look at the fundamental right to privacy, which has always been part of the Indian Constitution, has been conclusively reaffirmed in the last couple of years. And I'm going to use the regulations relating to sex testing as an interface to the fundamental right to privacy. I know there are a couple of sessions on hyperandrogenism and sport. I'm not going to, and I'm not competent to look into the merits of the issue, but I'm only going to look at the hyperandrogenism regulations through a privacy lens to try and unpack as to what privacy might mean in this context. And secondly, I'm going to look at India's data protection bill and its contours through the use case of biometric wearables, which is very common in sport now, but is becoming increasingly more prevalent. And I'll be happy to take questions at the end on any particular legal questions that might arise. So to get us all started, because it's early in the morning, I thought it would be useful to start with a little video.
Not really driving hard yet, is she? Remember, she's a world-class 400-metre runner. She's broken 4 minutes from 1,500. She's got the full armoury, and she's opened up another 5 metres around that final bend, and striding away down the home straight here. R.J. Wilson looks to be heading for second place, under threat from Raven Rogers for third, but Semenya across the line there, 1:55.69.
Facing somehow they're afforded another right that everybody else doesn't have. And that's what I don't see. You have to look at what you're doing in relation to the fairness of how that impacts everybody else around you. You can't just say, well, I feel like this, so I'm going to go into that sport and never mind everybody else that's already in that sport and is in that category. I'm just going to do what's the best thing for me. I think that's a kind of selfish way to look at it. It's a number of athletes, and could be a growing number, who have those elevated levels of testosterone. And it's not just about that either. It's the fact that essentially you have a body that has almost gone through male puberty and is stronger, physiological differences, the bone mass, the strength, not having to deal with periods, not having to worry about managing your menstrual cycle around competitions.
One more question to Casta. Sorry that I'm asking again, but the decision of the CAS can mean that the IWF is allowed to ask you to take a medicine that will change things in your body. Do you think that is fair, and would you do that?
I have no time for nonsense. So medication, no medication. Look, I'm an athlete. I don't have time for such things. You understand? So for me, it's their own decisions. Like I said before, my focus is more on for me getting healthy and compete. I really don't have time for nonsense.
This nonsense that Caster Semenya is referring to, of course, has an old history in sport, and it has very deep connections with privacy. In 1966, in the Commonwealth Games in Jamaica, sex testing was done through a physical examination of genitalia, together with what a female athlete described as a gentle grope. In the Pan American Games, we had what is called a nude parade, where everyone had to line up in order to have their genitalia checked. And this seems to be a classic case of a violation of privacy. In the case of Caster Semenya, of course, we have now moved on to seemingly more sophisticated methods of testing. But if we look at the 3-level assessment that is now mandated by the DSD regulations, then level 1 is, of course, a clinical test examination together with a preliminary endocrine assessment. Level 2 is a blood and serum test. But level 3 is still a full body examination, which is severely invasive and includes testing for whether there has been, amongst other things, clitoral enlargement. And if we look at this and take this as a test case, then I think it would be interesting to use this to understand as to what privacy is about. The Indian Supreme Court in 2017 said that the right to privacy is a right to be let alone. It involves a privacy over the body and the mind. As far as the body is concerned, we have bodily integrity, that we have a right to decide what we want to do with our bodies. And as far as the mind is concerned, it has 2 aspects. One is informational. We can decide what we want to do with our personal information. And the second is decisional. We can decide for ourselves. We are autonomous beings, can decide for ourselves as to what we want to do with our lives. It's important to note that, like every other fundamental right in the Constitution, this right is also not absolute. The fundamental right to privacy can be restricted and there are 3 conditions. First, the restriction must be by law. Second, that it must be for a legitimate state interest. And the third is that it must be by means which are reasonable, necessary, and proportionate. Now, if we were to apply these tests in light of the DSD regulations, there are some interesting questions which I'd like to throw up, but perhaps some preliminary surmises. Whether sex testing itself is legitimate or not depends on whether we consider this binary of male and female to be sacrosanct. Now, that's a much larger question, and I'm sure the sessions in the next couple of days will discuss that. But at this point of time, whether it's legitimate or not, it seems to be, since sex testing is accepted, but this may not be the situation for all times to come. Certainly, I hope so. The second, in terms of whether it is reasonable, necessary, and proportionate, we'll have to see as to whether the means in the DSD regulations that are used in order to determine as to whether a person has an advantage because of the additional testosterone levels that they have is the least invasive means by which this test can be carried out. Now, I don't know whether it's the least invasive means, but this is something that were it come to an Indian court, it would be tested. Now, there are two thoughts as far as this is concerned, which I'd like to leave you with. The first is that I understand that the IAAF and its regulations operates in its own legal universe. But the fact is that tests will have to be carried out in particular countries, at the first instance, perhaps by national federations, if someone were to participate in one of these restricted competitions, as they call it. Now, it seems that it would be an interesting legal question if someone were to bring these IAAF regulations to court in India, saying that there would be a violation of the right to privacy. I know that the IAAF operates in its own legal sphere, but it would be an interesting question because it's ultimately a question of a fundamental right. And secondly, is the question of who is the right to privacy against. In the standard understanding of fundamental rights, rights operate against the state. But that is an idea whose time has come and gone. Because we know today, with the large amount of private sector influence on our everyday lives, that the right to privacy is equally a right against private parties. Of course, this will require judicial adjudication, but I'm pretty confident that a right of this nature will be upheld against private parties. And the main way to do that is through a data protection legislation. So what is the interface between privacy and data protection? This can be explained in two ways. This is a long jurisprudential question, but I won't bore you here. One way of explaining it is data protection begins where privacy ends. So privacy tells you that you have a right. Data protection is the way in which that right is made actionable. The second is that data protection, which I prefer, data protection is a manifestation of your right over personal information. We know in this digital economy, and as the introductory speaker said, as a phrase that is tiresome, data is the new oil, which is essentially proxy for the fact that whether you call it oil or you call it currency, it's proxy for the fact that it's important, as in it's something that's significant. And because it's significant, as in your rights over that data become significant. And a data protection legislation is a way in which you protect your personal information. Now, however, that does not mean that your personal information cannot be used by anybody else. So what are these circumstances and conditions under which it can be used by other parties? That's where we have a data protection legislation. So I was thinking about an interesting way to talk about this, and then I came across the phenomenon of biometric wearables, which seem to have become all pervasive in sport and growing. The most recent article I read was one about smart clothing, and you can see that in this age of Internet of Things, biometric wearables is only going to grow. Now, earlier it was said that if a product on the internet is free, then you're the product. But as far as the Internet of Things goes, the product is not free, but you're still the product. And the fact remains that in this age of the Internet of Things, what are the different kinds of personal information that's being collected and what is it being used for? So, if we look at wearable devices, and I just made a list of some devices that are available in many markets globally, and the information that they collect: bone density, body lean or favored muscle use, body positioning, heart rate and cadence, heart rate, sleep and body temperature, impact on body, stress on body, brain activity, respiration, chemical analysis of sweat, temperature, ECG, and this is only scratching the surface. There's many other kinds of information that's being collected by biometric wearable devices. So the question that arises in this context is that once this information is collected, what can you do with it? Now, India has now its first draft of a data protection bill. As far as the status of this is concerned, it is not binding law. It is a draft which has been submitted by a committee to the government. In latest news, there will be another smaller governmental committee perhaps which will go into the bill to fine-tune some of its aspects, but everybody expects that in the winter session of Parliament, which is later this year, it is likely to be tabled in Parliament and become law soon thereafter. Whether it becomes law now or not, it's certain to become law at some point of time in the near future. So in terms of the data protection bill, what is it that is relevant insofar as particularly this personal information that is collected by biometric wearables is concerned? Some of it is generalizable, some of it is not. The first concept that's relevant in our bill is the concept of a data fiduciary. So anybody who collects data is a fiduciary. Now, for all the lawyers in the room, you know that a fiduciary relationship is a relationship of trust. So essentially, as an individual who's giving his or her personal information, the fiduciary has to hold that information in trust. So the data principal is the individual and the person collecting the information is the fiduciary. Second is that the remit of this whole legislation is personal data and sensitive personal data. There could be all other kinds of data that is relevant to sport, which is not a part of this legislation. The second thing to note is that it does not apply to anonymized or de-identified information, which essentially means that it does not apply if this information meets a certain standard of anonymization which the law will prescribe. The law applies to personal data and sensitive personal data. Now, particularly for information that biometric wearables collect, there's a lot of sensitive personal data involved. That's genetic data, health data, and biometric data, all of which is sensitive personal data. Now, if something is sensitive personal data, it can only be collected with explicit consent of the individual. Now, so the individual has to consent explicitly to that information being collected. And I think that this is the primary ground for processing that is necessary if you want to use this data. There is another ground for personal data which is relevant, which is called reasonable purposes. Data can be processed for reasonable purposes, which in the EU GDPR is called legitimate interests. But sport data related to particular types of sporting activity will have to be specified as a reasonable purpose. Currently, there is no such specification. The obligations on data fiduciaries are primarily threefold. The first is collection limitation. So if you want to collect information to improve player safety, which is ostensibly the reason as to why a lot of this information is collected, you can't collect information, say, relating to the player's race. That would not be relevant to the purposes of processing. Second, use limitation. Now, this has two aspects. First is that the use must be such that is reasonably necessary for the purposes of processing and reasonably expected by the individual. So if Juventus Football Club takes Cristiano Ronaldo's samples in order to improve his performance or to look after his health, then they can't share that with EA Sports to create a better version of Ronaldo in the next FIFA game. So there are use limitation principles that exist. There are cybersecurity obligations, which essentially means that every data fiduciary has to ensure that the data is protected and secure, whether through de-identification, that's anonymization, or through necessary standards of encryption. And finally, there is an overarching principle, which is a principle of fair and reasonable processing. Ultimately, it is on the data fiduciary to process information in a fair and reasonable manner. And the biggest criticism or biggest fear with biometric wearables and the information that they collect is that while they can be used for player safety and improving their performance, it shouldn't be used for contract renegotiations. And that line is really slippery. So this is an obligation on all data fiduciaries. Individuals, that's data principles, have rights. Now, the rights are to confirmation and access. You can access your information at any point of time. So whoever's collecting this information, you should have a record of all the information that's been collected and what it's been used for and who it's been shared with. And importantly, there's a right to data portability. Now, this is going to be a big one in the years to come, that you should be able to get your data back in a structured and commonly used format. This should allow you to switch from one product to another and not be captured by any one product in the market. The last point from the purposes of the bill is that there are some stringent penalties which follow the EU GDPR model, which is that it's up to 2% of global worldwide turnover or 5 crore rupees in case of some minor infractions. So if there's a data breach and you haven't notified it, that counts for that penalty. And in certain serious cases, so for example, if you've collected some of this data without the individual's consent, it could be up to 4% of the global worldwide turnover or 15 crore rupees. So there are some fairly stringent penalties which back up this data protection legislation. Now, I've got a note saying that my time's almost up, but I wanted to leave you with one thought, which is that data protection and sport, as in maybe the latest episode of an ongoing tryst between data and sport. It's not as if the interface between data and sport is a new one, though people are discovering purposes that are new and using it for things that we could never imagine earlier. But what is data at its core? Data is structured, processed information. And structured, processed information has been used in sport for a long, long time. It has been both used and abused. So in order to leave you, and since this is a group of sports enthusiasts, I thought I'd end with a slide which is, in my memory, my oldest memory of data that was used, or perhaps used stupidly, in order to determine a sporting outcome. This too was data. This too was a usage of data, perhaps not as sophisticated as we are in the ways in which we are using it now. Since this is a group of sports enthusiasts, I won't need to explain this, so I'll leave you with this slide. Thanks very much. So I was told that there would be some questions, so I'm happy to take any questions early in the morning if any of you have any.
Good morning.
Yeah.
I'm Teja Prakash from IIT Madras, and I'm working on sports technology development. So I would say that it is a very much interesting topic for me. And I would like to ask you a good question on data portability that you were talking about. Let's say we have collected some data with users' consent, and then we have developed certain platform or a product out of it. And then we have released that into a market with the user's consent, and then this person comes back and asks for the data, getting back of the data. And then what happens to the product part?
It's an obligation now on any product manufacturer to give the data that you have collected from an individual to the individual in whatever is a format that is prescribed by an authority. So suppose in your example, as in you have collected some raw information, your algorithms have worked on that information and you have come out with a product. Now that product is then being used by the individual. Now if the individual wants to know that, what is the personal information that you have collected about me, then that has to be given to an individual in a structured format. So that, and the hope is, and this is nowhere close to where we are now, that if the individual wants to move from your product to a competitor's product, then that data of the individual is not captured with you, and he or she does not have to fill up that whole to go over that whole exercise again. So that's the principle of data portability. It's essentially a principle from competition law to ensure that there is a level playing field, and that hopefully one day in the future, though as ridiculous as it may sound, we should be able to send WhatsApp messages through our Twitter accounts.
Thank you.
My name is Nidhi. So in the data protection framework that you talked about, you said the principal is the owner of the data, right? And he or she consents to give out the data to the fiduciary. But we also know that there can be consent fatigue. So how do you imagine that can be addressed?
Okay, so first, actually, the data protection law specifically does not address the ownership question, because the ownership question is a complicated question, because then it means that once you've given consent, you actually sold your data, and then once you sold your data, you could have alienated your rights. So actually, the relationship is one of trust. So we have not gone into the ownership question, but someone else, that is the data fiduciary, holds the data in trust and uses it for purposes that you are saying. In terms of consent fatigue, yes, as in I understand that consent fatigue, especially with the EU GDPR, as in is a concern that a lot of people have raised. But I think the concern is not such that we have to do away with the principle of consent itself. Because at the end of the day, the data protection law comes out of a fundamental basis of privacy, whose basis in turn is human autonomy. And yes, human autonomy, as in you may not want to exercise your autonomy all the time, like we all do, as in we say, I agree to most of these forms, and we do it anyway. So there is a problem. The onus is on us. And I am hopeful that there will be solutions that will develop for consent fatigue. If I were to give you an example, and I know this is a group of lawyers, so perhaps this question may not have its intended answers, but in any other group, if I were to ask for a simple show of hands as to how many people have read a consent form before saying, I agree, the answer is typically 0. Okay, and if there's someone who's raised their hands, it's because they're a lawyer or a data protection lawyer, to be more specific. Now, the fact is we don't read our consent form. So what if that consent form were to be replaced by a simple data trust score? So if you got a score which said that, okay, these guys have a 0 on 10 in terms of their privacy practices. So maybe that will make you think about consent more than you do now. So I think consent fatigue is an issue, but it can be solved. Yeah. Do we have time for one more? Yeah. Okay.
Good morning, sir. I'm Parth Mehta. The way the GDPR envisions that you can delete your digital footprint, does the current bill in India also envision something similar where you can delete your information from a database, not transfer it, just remove it from there?
Yeah, so in the current bill, as in there is a right to be forgotten. And a right to be forgotten is a long and complicated issue, difficult to implement. But in principle, there is a right that it's not a right to automatic deletion, but there is a right to be forgotten that exists in this bill. In my view, we should have had a right to deletion as well, but unfortunately we don't.
Yeah, Olga Nandan. Just in conclusion, we have sports industry here, people who are on sort of leadership positions working on this. So as the law comes into effect, how best can the sports industry prepare itself? And in particular, how much room is there for industry standards? When you talk about legitimate interest, reasonableness, and other things like that, it's also incumbent on industry to find its own balances. So a little bit of advice on how an industry like the sports industry can prepare, knowing that 6 or 9 months from now, we're going to have a data protection law in place. How do individuals, organizations, even associations, let's say, prepare themselves for this? What are your words of advice, having been part of that drafting process?
Sure. So first, as background, because Roshan had asked me to think about this question earlier, I went through all the comments that had been submitted to the committee. There were about more than 8,000 comments, but the word sport didn't appear once in those comments. So I think it's critical that the sports industry is in advance does 3 things. Number 1 is that there is going to be a data protection authority that is going to be set up. The data protection authority is going to notify certain purposes as reasonable purposes that is directed specifically at specific industries or use cases. It's critical for the industry to get together and try and specify certain purposes for which this kind of data for purposes associated with sport can be used and processed. So I think that's the first thing, that you can't do it now, but you can start the conversation now. The second, which I think is going to be the part of the law that's going to become immediately applicable, is relating to cyber security and data breach notifications. So I think it would be very important to I'm sure you have it already, but if you don't, then have those contracts in place for de-identification wherever you don't need personal information. So de-identify and get out of this law, because that's one way. And the second is encrypt and make sure that it's secure. So I think that's the second thing to do. And the third thing to do is in terms of genuinely, I think this is introspection that every industry needs to do, is that what is the data that we actually need? Because currently, especially in this world of big data, there is this, in my view, slightly simplistic understanding that let's gather all the data first, and then we'll see what we want to do with it. I think it would be a useful question to ask as to what is the data that we actually need, and to collect only that data. So I think that there is a long way to go. And the last point is that the data protection law is intended to be a framework legislation. So what is going to sit on top of it are codes of practice. These codes of practice will be sector specific. Okay, so it's important, and especially because this sector doesn't have a regulator. So this code of practice may have been made by the RBI in the financial sector, but because this sector does not have a regulator, instead of being caught in 20 sectors, because I'm guessing there will be some financial information, there will be some, as in there could be some health information, and there could be some information in sectors that are regulated. I think it would be important for the sports industry to gather together and try for a code of practice for personal data relating to sport. And that should trump all the other regulations. I think these are some formative thoughts.
Thank you so much.
Thanks very much.
Thank you, Dr. Sen Gupta. I think one of the things that stood out for me particularly was the fact that you mentioned that in the 8,000 comments, sport was not mentioned once. I think as it's a responsibility of all of us gathered here and our vast network within the sports industry in India to get moving on conversations that are important. And I like I said, data is the new oil, data is the new currency. It's important. Another thing that stood out was the hefty penalties in terms of breach, which shows that even the government's taking this really seriously. Regulatory authorities are taking this seriously. So it's important for us to stand up and start having those conversations. I now request Nandan, to the director of the SLPC, to please present Dr. Sen Gupta with a memento.